we're glad that you're joining us. We want to thank you for joining us on behalf of the Legacy Advisor Group. My name is David Saunders. I'm here with my partner, Ken Jones. So we have a special guest. I know we have the same haircut, but we are not brothers. But it'd be okay, man. We both go to the same barber for getting our haircut. That's God, but you can't argue with that, right, Josh?
Right.
So we have Josh Kelly here tonight. We've been working with Josh for nearly a decade. His firm is Hirschler Law. They're downtown. They have a few offices in the state of Virginia. He is one smart man when it comes to taxes and estate planning. Mm-hmm. Not only is he a JD, but he also has a master's of tax law, which is quite impressive. And then for you football fans, he even also was a center at West Virginia University. So we're lucky that we have you on the team, and we're glad that you're here tonight with us.
I appreciate it. Happy to be here.
Good. Yeah. So I'm then going to pause and turn it over to my buddy here, Ken Jones, to kick us off.
That's right. And before we get started, I want to again thank all of you for coming out tonight. We do have a couple of housekeeping notes. First off, this is going to be an interactive webinar. So if you have questions on estate planning that you'd like us to field to Josh, this is going to be Stump the estate planning attorney.
I didn't sign up for that.
You will notice in your Zoom a Q&A box. Feel free to put those questions there. If the questions get to be too numerous for us to cover, we will make every effort to cover all the questions tonight. But if for some reason we don't, we'll be sure to get back to you with your specific question. And we look forward to doing that for you. And again, thank you again for attending. So, Josh, I'm going to kick it off with the first question. And as financial advisors, it's our job to make sure that our clients have a comprehensive financial plan, and that includes estate plan. Mm-hmm. So the process of estate planning, however, can be a little uncomfortable for advisors and clients because there's some conversations that are just hard to have. Mm-hmm. And they don't know where to start. So can you tell me, as an estate planning attorney, what is the essence of a good estate plan, and what does that look like?
Yeah. So that's going to look different for everyone, but I mean the basics of a good estate plan. I mean, what you're trying to do is essentially plan for the kind of the smooth transition of your assets to your intended beneficiaries, and as I said, that's going to look different for different folks. Mm-hmm. I mean that may include the preparation of a will, a trust. There's multiple kinds of trusts that could be included in that. But that also includes like looking at beneficiary designations on life insurance policies, 401ks, transfer on death deeds. I mean, there's a lot of different kind of components that can go into that. But essentially, the end goal is what you're trying to do is kind of planning for the inevitable and having a plan in place for the kind of the transfer of your assets, your estate, to your intended beneficiaries.
Okay, that's great. The one piece that is one of those things that people have maybe heard of or maybe have some idea about is probate. Before we get into that fun subject, I want to touch upon, it's an alarming statistic, and this is one thing that I feel that we really encourage our clients to do, and make sure that it is something that is talked about and that is done, is making sure that there is some type of estate planning done. And the one thing that we are alarmed by is the statistic is somewhere between 65 and 75% of Americans don't have or have not done an estate plan, and it's really somewhat alarming. And I sort of want to throw it over to Josh to say what where's why is there such a hang up? What's the problem with, people not getting it done?
Yeah, I mean, I think there's a few reasons for that. I think most people don't like kind of facing their own mortality. I mean, nobody likes thinking about death and kind of planning for death. So that's obviously, I think, a component of it. I think in some cases, people just always feel like they have more time because it's not something that nobody thinks they're going to pass away today or tomorrow. Right. And it's always something, well, I can think about that later. I can think about that later. And sometimes later doesn't come. I think also in some cases, just the cost, and people are kind of weary of legal fees and paying an attorney to advise them and assist them with an estate plan. I think there's also a misconception that if you don't have millions and millions of dollars or significant assets or a complicated family dynamic, that it's really not that important to address that, because your family will just figure it out. Your heirs will figure it out. But it's really, whether it's a simple situation, a complex situation, a large estate, a small estate, you and really your heirs are better served by you taking the step to have a plan in place and going through that planning process, whatever that looks like for you, rather than relying upon the laws of the state that you reside in to dictate how your estate is going to be distributed.
I have experienced this firsthand. I'm sure everyone out there has experienced where things have been handled really well for an estate, separate from the loss. The loss itself is hard, but on top of it, the difficulties of managing things, even when there is a clear plan. And then you compound it with not having a plan, and it can get really sideways for a lot of people. And that's, I think, thank you for clarifying a little bit more of the pitfall. It's astounding to me sometimes to see where, hey, why didn't that billionaire, why didn't he finish the trust? I mean, for him, it was really a tax thing too. And now he's got to sell, the skyscraper, and they're taking their name off of it. I mean, I know a lot of people can't relate to that, but as we transition to this probate discussion, I think I'd like for you to hear, who's affected by probate? Is it just the millionaires? Is it, what can you help us with understanding probate?
Yeah, so probate at a high level is basically the process whereby a court in the jurisdiction you reside in is going to oversee the administration of a deceased party's estate. And unless you take proactive steps to plan and have planning in place to avoid probate, I mean, everyone's estate will go through probate in some form or fashion when you pass away, unless, like I said, that you are proactive and kind of do some planning while you're living to keep assets out of probate.
Gotcha.
Any asset that passes pursuant to a will, or any asset that passes pursuant to the laws of intestacy, will be subject to probate.
What do you think is the number one asset that most people think or don't think, that'll just go to my heirs? It won't even go into probate, or, is that even a fair question for you?
Yeah. I mean, I think probably most folks that have a retirement account, or, maybe a residence, I don't know, that there's kind of a misconception maybe that won't go through probate, but either of those can go through probate, depending on whether you have beneficiary designations in place on a retirement account, depending on how your residence is titled. There's really no particular asset that is totally safeguarded from going through probate. It's all a matter of how it's titled.
Okay.
How ownership's structured.
A quick question for you there. Now, if you own property in different states and you pass away,
Mhm.
is it the state that you pass away in? Is that the court that you're going to be dealing with for all of your assets?
So if we're talking about real estate assets, that would be handled by the state, by the laws of the state where the real estate is located.
Yeah.
So, for example, I think we're going to focus mainly on Virginia
That's right.
tonight. But if y'all's clients are like my clients, they frequently have beach houses in North Carolina or mountain property in North Carolina or West Virginia or a second home in Florida, something like that. Your estate planning documents that are drafted in Virginia would still apply, but if you own property in one of those other states, then the probate laws of that state are going to apply, and sometimes a second probate proceeding is necessary in that other state to effectively handle the transfer of that real estate asset to the beneficiary.
And real property too, so cars or boats, those types of things would also
if they're titled, if you have a boat in Florida that's titled under the laws of Florida, then it would be subject to probate in Florida.
So that can get real complicated.
One of the items that we hear about is, the estate tax. And then people sometimes confuse an estate tax with a probate tax. And can you help us sort of understand the nuances in between those two taxes and the importance of understanding that what you have there and some of the costs?
Yeah, absolutely. And we may come back to the estate tax a little bit later on, but basically the estate tax is a federal wealth transfer tax. Whether there is in the Internal Revenue Code, there is a level at which that tax applies, whether you give things away during life or you give things away at death. If you transfer assets with a value that is above that threshold, then the federal government is going to assess a tax on the value of that's above the threshold. In 2025, the applicable federal gift and estate tax exemption is $13.99 million. That's per person. So a married couple, roughly $28 million. So that doesn't necessarily apply to a lot of folks, but it is out there, and there's the possibility that exemption may come down, may be reduced in the future. It will under current law. We'll see what happens between now and the end of the year as to whether that happens. The federal estate tax is a 40% flat rate tax. So if you have a $20 million estate and roughly $14 million exemption, the $6 million between 14 million and 20 million would be taxed at a 40% rate. So we're talking about $2.4 million in estate taxes. Virginia doesn't have a state level estate tax. There's some states that do, but Virginia does not.
Okay.
But Virginia does have a probate tax.
Right.
The probate tax is nowhere near as steep of a penalty as the federal estate tax, but it applies regardless of the size of your estate. If you have assets that pass through probate, then the Virginia probate tax will apply. It is 0.1%, and that's a state level tax. And then depending on the county or city that you reside in Virginia, they may apply an additional county or city level tax that's a third of that. So basically 0.133 of a percent.
So let's drill down on that probate tax a little bit and help our friends here tonight understand that, because it sounds like everyone, if you have anything, is going to perhaps have to, consider probate tax. And, if let's just say, someone didn't have their house deeded properly, and the deed wasn't in the name of a trust, or if it wasn't done as a TOD, which is transfer on death. I happen to be the executor of my brother's estate, and now what? So I got to take care of my nephew. I want to make sure, all the money that is there hypothetically goes to him. Now what happens? what the house didn't, the house was just named to my brother. And now I have to go, what do I have to do? Of course I got to go to the courthouse.
Yeah. So just to kind of walk through some of the steps of probate. And again, this is Virginia specific. It varies state to state. But in Virginia, kind of the first step is you would schedule an appointment with the circuit court in whatever city or county the decedent resided in. If they have a will, then you would when you schedule that appointment, you would bring the original will to the court to record that.
Gotcha.
If you don't have a will, then you have to bring what's called the list of heirs. So the intestate heirs of the decedent, you have to provide that list to the court. And then you would be appointed as the personal representative of the decedent's estate at that initial qualification meeting. And then that date kind of sets the timeline for the estate administration. So once you have the personal representative appointed, there has to be a notice that's provided to the heirs, either the legal heirs or the beneficiaries under the will. That has to be done within 30 days of the appointment. The personal representative is required to file an inventory with the court, which is basically a list of all of the decedent's assets that are part of the probate estate. And you have to assign a value to those. So you have to either have an appraisal done or look at tax assessed values for real estate potentially, look at fair market values of investment accounts, bank accounts, all of that, and provide an inventory to the court.
It sounds like a lot of accounting.
Well, and then you have to file an accounting, which basically covers your starting point on an accounting is the assets that are reflected on the inventory at that value. Your closing point of the accounting is any distributions that are made from the estate, and you have to account for any income that comes in, expenses that are paid, assets that are sold, anything like that. And that's really the burden, at least in Virginia. That's kind of the burden of the probate process is the preparation and the filing of that accounting. In Virginia, every jurisdiction has an individual who is the commissioner of accounts for that city or county. And the sole role or sole function of that office is to review estate accountings and trust accountings or guardianship accountings. And it's a helpful function because you kind of ensure that the terms of the will or the intestate heirs are kind of receiving things in a proper manner, and the personal representative is carrying out their duties in a proper manner. But it's a meticulous process for that personal representative, just because of the kind of the substantiating verification of expenses that you have to provide, and all of the kind of the supporting documents that have to be provided. Because if you're off by a penny, then the commissioner is not going to approve that accounting. And so it's just a meticulous process.
And is there a way of sort of like, I mean, I know there's a probate rate in the state of Virginia, but could you say, like, if someone had a house that's $400,000 to $600,000, and then they had some cars, and some bank accounts that weren't properly titled, and it went into probate? I mean, are they, with the time and all that, does that take like a year to clean up?
Yeah, typically it varies based on the circumstances, but typically it's a 1 to 2 year process, kind of moving through probate. And just kind of to touch on the fees. I mean, we talked about probate fees. So there is a probate tax that applies. There's also the inventory when that's filed. There's a fee that the commissioner of accounts charges when the inventory is filed. When the accounting is filed, there's a fee that the commissioner of accounts charges. I mean, if at a $1 million to $2 million estate, which is if you're talking about a residence and potentially retirement accounts or investment accounts and tangible property, cars, things like that, it's not, especially with the real estate values now, it's not that hard to get into that range. I mean, you're probably talking about something in the neighborhood of $3,000 to $7,000 just in direct fees that are paid as part of the probate process, and that doesn't begin to kind of address the time and effort that's required of the personal representative to navigate that. Your executor. Yeah.
Wow. Man, I don't want to state the obvious, but but let's talk about, there are certain things that you can do, and that's what your expertise is in, is that if there are simpler estates that, you ultimately, can you eliminate probate? I mean,
yeah, absolutely. If with proper planning, as I said before, probate is going to apply to anything that passes pursuant to a will or that passes pursuant to intestacy. If you and I have a joint bank account and I die, well, my will doesn't direct what happens to that account. We own it jointly. Now it's your account. So
Gotcha.
things that are owned with right of survivorship, whether that's a bank account, whether that's a residence, whether that's a vehicle, things that have different types of assets that have beneficiary designations in place. So whether that's a beneficiary on a life insurance policy, a beneficiary on an IRA, or just a regular bank account or investment account that has a TOD, transfer on death, or POD, payable on death beneficiary designated on that account, that's not going to go through probate.
gotcha.
If you have a trust as part of your estate plan and you title assets in the trust while you're living, that's not going to go through probate. And that's one of the reasons that kind of even for the folks that don't have super large estates, trusts are a very frequent component of the estate plan because of probate avoidance. And there's other reasons too, but that's frequently one of the primary reasons for having a trust as part of the estate plan.
So I want to stop on something that you just pointed out there with regards to trust and having a trust, and specifically funding a trust. Like what, when someone says, "Hey, you need to fund a trust," what does that mean?
Yeah, funding a trust is essentially the process of transferring assets to that trust. Having a trust as part of your estate plan is great, and there's kind of there can be benefits to that aside from probate. But if your aim is to use that trust as a mechanism to avoid probate, it doesn't do any good if you're relying on your will to transfer the assets to the trust. You have to proactively either change the ownership of your assets to the trust or have beneficiary designations in place on those that direct them to the trust when you pass, in order for that to be an effective kind of probate avoidance strategy.
Okay. No, that's great.
Okay. Well, I don't want to beat a dead horse, but we probate is one of those things where it seems, as we learn more about it, it really affects everybody. And if you have the right plan in place and make sure that you're turning the stones to understand how the assets transfer, and how those assets stay out of the hands of probate, you're much better off. And it certainly helps your heirs with a smoother transition.
Yeah, when I am working with clients, any client that has recently gone through the process of probate with a sibling or a parent or whomever, I don't need to do any arm twisting with them for them to see the benefit of having beneficiary designations in place, having the transfer on death deed for their residents, having the trust in place, and having that funded, because they know the headache that comes with and the cost that comes with probate. So they are easy to kind of motivate to take that proactive planning step.
Cool. Thank you for all those juicy nuggets, and it's like one of those things where they say health is easy. It's easy to do. It's also easy not to do. So we all know we have to keep drinking water. We have to eat moderately healthy and eat our vegetables. Our estate planning can work the same way. You just got to work on it a little bit to understand where those assets are going and keep them out of the hands of, more government does not help. So we'll leave that where it is and we continue on. So let's help out our business clients with a little heads up on when you're meeting with people and you're talking through the business, the business entity as an LLC, and all the things. What are some of the aha moments that people are like, holy cow, I never thought that would lock everything up, or that would freeze operations, or something that people need to really have a good pulse on.
Yeah. So, I mean, for business owners, I mean, all of the other kind of general estate planning concerns or concerns with probate will apply. But specific to them is, I mean, if the goal, and I don't think I've ever worked with a business owner that this wasn't the goal, is for the kind of the transition of that business to somebody so that it can kind of continue to operate and be something that survives the current ownership team. But aside from the normal issues, I mean, some really unfortunate circumstances I've seen where you have a sole owner of a business that passes, and now nobody can run payroll because they were the only one that was authorized on the payroll account, the only one that was authorized to sign checks, the only one that could complete any transfers with the bank, file payroll tax reports, file sales tax reports, and things like that are not something that typically comes up in the estate planning conversation. But when you're a business owner, it's something that can become an issue. And I mean, I've seen circumstances where the surviving spouse or the child of the business owner now is having to write checks from their own personal account because they've got to make sure that the employees get paid because they need the business to stay open.
Right.
And that's just a kind of a practical, like, boots on the ground issue that a person that's not a business owner doesn't need to think about. But it's all the more reason for folks that are business owners to take steps to either have a buy-sell arrangement in place, have a transfer on death designation in place on your stock certificates or your LLC operating agreement, have some plan in place so that if something happens to you, the business is not left in the lurch, and there's kind of an immediate plan in place for somebody to step in and be able to make kind of those day-to-day decisions.
Yeah, there's two things that I hear you saying. There's the one where they're going to have the estate stuff on the business, but the operation of keeping the thing going is something that should not be, just glanced over lightly. Where looking through, like, hey, look, we got to make sure all the loans and all the stuff that people have access to that are a trusted ally, like a partnership, that we're all on the same page. If something's gone, something changes, that we know where to go and we know what to do. Help us out with like the sort of buy-sell agreement structure.
So
a little bit more about that.
I mean, that can take a lot of different forms. I mean, as I said a minute ago, I mean, typically the business owner's goal is not when they pass that the businesses wind down and that's it. I mean, there's some goal that it's going to perpetuate and someone else is going to step in and continue to run that. If you have a family member or someone that you've identified that maybe it's a kind of a key employee and your plan is to just leave the business to them, I mean, that can be addressed as part of just a normal estate plan, will, trust, whatever your estate plan looks like. In a lot of cases, though, there's not a direct kind of family member that someone is leaving a business to, and so they want, the business owner wants their heirs to benefit from the value of that business, but they want somebody else to step in and manage it and run it. And so you have a contractual obligation with that other party or those other parties that says, if I die, then you're going to buy the business from me, and here's the value that we've determined, or here's how we're going to determine the value at that point. And you are now contractually obligated to purchase that business, or I mean, it can be structured different ways. They're either contractually obligated to have to, or they have the option to buy that from your estate, from your trust, however kind of the ownership is structured, to enable those folks to continue to operate the business and do what it's supposed to do, but also enable your heirs to benefit from the value in that business that you created.
Yeah, that I could see being, if not in place, where you have a key employee that's not a family member,
Mm-hmm.
and then you have your wife and
Mhm.
your kids, and they are like, hey, dad killed him, and now he's gone. And,
Yeah.
they're left with, they don't want to run that business. Maybe
Or
they
they
know
don't know
nothing
how.
about it.
Yeah.
Yeah. Like,
Yeah.
now what do we do?
Yeah.
And having the conversations about, and I'm sure the key employee wanted to step in and
Mhm.
be like, I want to do it. I want to
Yeah.
do this. And now if there's nothing there, if there's no contract, then where do you go?
Yeah.
And that's a tough situation.
It is. It is. Because then
Yeah.
at that point, you're just relying on your executor or your trustee or your family members to figure it out. Are they going to step in and like you said, run a business that they don't know anything about?
Right.
Or they're going to have to negotiate with somebody, whether it's your key employee or a competitor or something like that to sell. Or,
Yeah,
or
then
they just
they're coming in and being pushed into being
Yeah.
becoming an expert real quick about
Exactly.
what's this business worth.
Yeah.
And if dad would just have done the documents, spent the funds and got the attorney and did that and got the employee in place, it's like,
Yeah.
it just happens.
Yeah.
It's still difficult, but
Yeah.
it certainly has a structure, a lane for it
Yeah.
to run on.
Yeah.
So, yeah.
And that's just the business succession process is the planning process is not something that happens overnight. I mean, it takes a period of time.
Yeah.
And the earlier that you can kind of begin that process, it helps. The longer runway you have, the easier it becomes, and the more strategic you can be in what you're looking to do.
Ken and I know that firsthand.
Yeah.
From
Yeah, you do.
working with our partners, Philip and Mike,
Yeah.
then buying the business from Michael Thaler, and it it was one of those things that it did take. It took some time, and it was a great transition, and we all understood it. But if we all of a sudden weren't having the conversation, I can see where it was like all of a sudden, who's going to do what?
Yeah,
we never had those issues, so that was good planning on our part.
Well, and credit to Michael too for beginning that process.
Yes,
years ago. Yeah,
both Michael Thaler and Mike Mills really kicked it off the right way.
Yeah.
So, okay, let's then take a moment and transition into some fun area of estate planning. I know we started with the tough stuff, with the taxes and the probate, but this is really where things can get fun, and we help our clients with and dream about and because why are we doing all this? Why are we working so hard? Why are we building it for? And this is the area where we get to sort of say, hey, how can we help people in our family? How can we help nonprofits that we love? And how does that work when we want to give and do it right in our estate planning? I know it's a big question, but you got to sort of you're the guru, so we're throwing you a big matzo ball right there. So where do we start with helping plan your legacy?
I mean, it depends on kind of obviously the goals of the individual, and if charitable planning is a part of that, there's a lot of different options that can be weaved in, whether that's through kind of lifetime gifts or kind of gift planning or planning for distributions and gifts that are going to be made at death. There's a lot of kind of more complex trust planning structures that we'll look at for clients that who have larger estates, who are looking to kind of make gifts, whether that's of the family business or interest in the family business or other kind of highly valued assets. There's a lot of different structures involving, like I said, irrevocable trusts. When we talked about trusts earlier on, typically we're talking about revocable trusts or living trusts that you can, as the creator, you can amend or revoke when we're talking about kind of special or trusts with specific purpose for gifting and legacy planning. Those are typically irrevocable trusts.
You can't undo
it. And you can't undo it. And it has to be that way kind of for tax planning purposes. But I mean, just from a charitable planning perspective, charitable remainder trusts are a frequent tool that we use, where you're, I don't know, want to kind of dive into that.
I mean,
charitable trusts or
what can you give us an idea of like what's the profile of a person that would want to do a charitable remainder trust?
Yeah, I mean, typically it's someone that has not necessarily a taxable estate in today's kind of estate tax environment, but a significant estate where they're not necessarily reliant upon the wealth and assets that they've accumulated to live. They don't need it to live on. Okay. They can kind of part with the control and the reliance on some of that that have, I mean, where they have charitable intent and they want to kind of do some good for the world with what they have. And it's those types of clients are typically fun to work with. They're good-hearted folks, and typically that's a fun planning process when you get to think about some of those things and help people kind of achieve what they're looking for from a charitable component, but also there's some tax planning benefits to that too.
And that's the nice thing. I mean, it's when you have someone that's charitable minded, they're probably going to do it anyways.
Yeah.
Mm-hmm. But on top of it, to have some incentives tax wise that gives them some way of almost saying thank you for doing that, in a way that it isn't, you're not going to get more tax for doing it. There is going to be good incentive for doing it, either for a charity or maybe even grandkids of some sort. I know what comes up from time to time is the grandparents want to do something for the kids, and they're doing the toys, but they want to do something else with maybe education. Can you talk about that a little bit?
Yeah. So from a kind of a non-charitable planning, when we're thinking about folks that want to kind of leave legacy to family members, there's lots of kind of different gifting strategies. I mean, we talked before about the estate tax exemption. I should say the federal gift and estate tax exemption. There's a lot of kind of exemptions to that, or exceptions to that. One of which is you can make what are called annual exclusion gifts. What the limit now is $19,000 per year that you can give away to any individual without using any of your gift and estate exemption. From an educational planning perspective, what folks sometimes do is use those to fund 529 plans.
Okay.
And one of the advantages of kind of combining those two approaches are you can basically like super fund a 529 plan with 5 years worth of annual exclusion gifts. So if you have a married couple,
grandma and
grandpa want to and have the ability to kind of give grandkid $19,000 each. So that's $38,000. If you multiply that times 5, 190. My math is right. Yeah. You can fund a 529 plan with $190,000 in 1 year and spread that over 5 years for gift tax reporting purposes, and that's a great start for little grandsons, little granddaughters.
Right. And there's no they don't need to have a document that says they're gifting. It's just what the law is, and they can do it. Right?
Correct.
There's no They don't have to have a gifting trust. It's just hey, this is the state that we live in. Yep. You can give gift the way the gifting laws work, guidelines. You can just do it. It doesn't have to be a
and in
complicated
Virginia,
process.
Correct. And in Virginia, there's a state tax benefit to doing that as well. You get a credit for a portion of what's contributed to a 529 plan.
Yeah, that's great.
How about getting into the donor advisor side of things, and how that can work for folks with maybe they're unsure of, hey, I know I need to start putting money away for something because I've done well. I just don't know what. So because people, it's a big buzzword about, what are these donor advised funds, or whatever, Can you help us about, how you've talked to clients about that?
Yeah. So a donor advised fund is basically, a charitable planning vehicle where you you have an account that is managed by a financial institution that it is set up purely for charitable purposes. So when funds are contributed to the donor advised fund, you can't pull it back out. Like you have contributed that to an account that can only be used to support charitable causes, but it doesn't have to be used in any particular time. There's no time frame. There's no required distributions that have to be made from that account in any particular year. So kind of years ago, folks would more frequently set up private foundations, which are very expensive to set up. They can be very expensive to maintain. But if you wanted to kind of have your own family kind of family charitable planning endeavor, that was the route that you went, because you could control that. You could involve family members, kids, grandkids, and basically kind of have a family legacy of charitable planning and do that through your family private foundation. Well, as donor advised funds came along, it basically allowed folks to have all of the same benefits of kind of the family foundation
structure,
but none of the headache of the setup process and the maintenance, kind of annual maintenance process, because there's somebody else, the sponsor organization, that is doing all of the legwork.
Mm-hmm.
You are just deciding what you want to give to the donor advised fund each year, and then if you would like to make any charitable donations from the donor advised fund, you're deciding that. But it's nice because, and I should say, with a private foundation, there's a requirement that the private foundation has to give away at least 5% of its assets every year. There's no similar requirement with the donor advised fund. So if you want to contribute a large sum to that and let that sit there for 10 years and then decide to start your charitable planning then after it's grown through the investment of the funds in the donor advised fund, then you can kind of start the charitable distributions down the road, but you get the current benefit of a charitable income tax donation deduction for income tax purposes when you fund the donor advised fund.
So that's great information. Can you talk to us about the difference? We already talked about charitable remainder trust. Could you tell us, what's the difference between a charitable remainder trust versus a donor advised fund?
Yeah.
As far as clearly one requires there's one required distribution, and the other one doesn't. Is the tax benefit a little different as well?
Yeah. So a donor advised fund, like I said, is it's basically an account that someone could coordinate with y'all to set up a donor advised fund, decide the amount that they want to put in there, either at one time or on an annual basis. And you get a current income tax deduction for whatever you contribute to your donor advised fund. With a charitable remainder trust, you are working with an attorney to create a trust agreement and naming a one or more charitable organizations as beneficiaries, which could be a donor advised fund. Donor advised fund could be the beneficiary of a charitable remainder trust.
Okay.
But you are making a one-time gift to this trust and retaining either retaining some type of income stream that's going to be paid by this trust on an annual basis. There are certain requirements as to kind of what that looks like. But basically what you're doing is the way that a charitable remainder trust works is either the person who's donating the assets to that trust or someone that they designate as the current beneficiary is going to receive a payment stream either for a period of years or for that individual's lifetime. When that period expires, whatever is left is going to be turned over to a charitable organization at that point. And you get the person donating to the charitable remainder trust gets a current income tax deduction that is equal to the present value of the calculated value of the remainder interest that is going to pass to charity. So there's a whole host of calculations that are involved in that to determine the current income tax deduction. Versus with a donor advised fund, it's really simple. If you put $50,000 in, you get a $50,000 charitable donation deduction.
Wow. So they've really made it easy they've come a long way from the private foundation
Yes.
days. So they're not working you out of the job, though.
No, there's certain
Giving you
situations
more
where
work. Yeah.
sometimes folks want to make a charitable donation, but they do want that income stream
Mhm.
for a period
Right.
of years or for their lifetime. And that fits really well because you get current income tax benefit. You also have kind of a guaranteed income stream coming back from that trust, but you know that at the end of that term, your donor advised fund or your charity is going to be the ultimate beneficiary of what you contributed.
And it sounds like donor advised funds also provide you a little more flexibility for tax planning purposes throughout
Correct.
the life of the fund, because you can essentially, if you wanted to put a bulk amount of money in this year and then wait next year and then put more money in, you can do that fairly easily with
Correct.
donor advised fund.
Correct.
Charitable remainder trust, it's a little different depending on the type of trust you
Exactly.
have, right?
Exactly.
So
Our business owners, typically when they do a donor advised fund, they're like, I want to get this thing going. I'm not sure what I'm going to do, but I'm charitable minded. I just want to put it in there.
Mhm.
And I know having the money ready, I'll know what I want to give to when it comes.
Yeah. It gives you
gives them that
Gives them that
flexibility. And I
flexibility.
think that's
Yep.
really, because there's a lot of people that like, they know if I don't do it, I'm probably not going to get to it. But if I start it and I don't have all of the exact details,
Yeah.
but I'm a giving person, then they can back into that piece when they find where they want to be more purposeful with the donation.
Yeah.
Which is really cool.
Absolutely.
Yeah. So, Ken, do we have anything else we'd like to explore this evening from our guests out there in the world of the internet?
Yeah, just a reminder, we are taking questions for Josh. So if you have any questions, feel free to put them in. I've gotten a number of questions already. And so I figured we've got another 15 minutes. As I said, we are going to try and get to as many questions as we can. If we don't answer your question or we need to get some more information to you, we'll certainly take care of that after the webinar. So Josh, I'm going to kick it off with a question for you here. So if a person has a revocable trust, do they need to identify beneficiaries on assets accounts as well, or can they just utilize the trust and give percentages there? So, I mean, it sounds like what the person is asking is that if they have an account out there, do they need to actually have listed beneficiaries, or will the trust take care of that if it's being TOD to the trust?
Yeah. So before we get into this, I just want to say I'm not providing legal advice to any individual as I answer these questions. But
spoken like a true lawyer. That's right.
Yeah,
absolutely. Education.
Yeah. But in general, if you have a revocable trust as part of your estate plan, that kind of lays out how your estate or how the trust assets are to be distributed, and the intent is that the specific account would be distributed in the same way. If the account references the trust as the beneficiary, then those account proceeds would flow into the trust, and then the trust would direct the distribution of those account proceeds as well as the other assets in the manner that the trust agreement provides. So, and that's frequently when I'm talking with clients about beneficiary designations. It's if they have a trust, it's typically far easy to take their 2 accounts or 22 accounts and just name the trust as the beneficiary of all of those, so that it flows into the trust, and then the trust will then direct those out rather than naming different beneficiaries on each account.
Okay. Oh, that's good. That's a great answer. So we're going to stick to that vein with regards to titling, because that seems to be a big topic here. With regards to, let's talk about, people's normally their largest assets, maybe outside of a retirement plan, which is their house. If you have, a spouse that's the primary beneficiary on a house, or if it's owned jointly, do you need to update a deed on a house so that the trust, to make the trust a contingent beneficiary, if you will?
Yeah. So with regards to residences, I mean, there's a few options there. I mean, in Virginia, There's, for folks that are married, there's the option to title the property as joint tenant, or excuse me, tenants by the entirety, which is essentially a right of survivorship. So if one spouse passes, the ownership vests 100% in the survivor. If the goal is to have kind of another automatic transfer, if both spouses, or if it's a single individual when that individual passes away,
Okay.
yeah, the ownership can be transferred directly to the trust, and the trust is the owner now, or Virginia law also allows what are called transfer on death deeds, which essentially act in the same way as like a transfer on death designation on an account. There's an extra step there because it's real estate. It requires a deed that's prepared and recorded in the jurisdiction where the property is located, but essentially says that when the owner or the owners, if it's a joint ownership situation, when they pass, that the title to the residence automatically transfers to the beneficiary or beneficiaries that are named in that transfer on death deed. And that, if you have a trust, can also kind of be kind of layered with the trust, so that the TOD beneficiary on the deed is the trust.
Okay.
Let me ask you this about that. So there's I'm going to go back to probate, and one of the things, when handled properly, probate is a public record, right? Correct. And some people like to keep their things private.
Correct.
So talk to us a little bit about making sure that if you are a private person, and you want to keep things out of the limelight, because as you probably have seen, where people, if someone passes and you got the ambulance chasers, they're going to the courthouse and they're digging through records.
Yeah.
So how do you prevent it?
Yeah. So as you said, I mean, any probate documents, they are filed with the court. They are public record. I mean, anybody that wants to go down to the courthouse and request copies of those can do so. That is another benefit of having a trust as part of the estate plan.
Okay.
Trusts are not subject to public record. The only parties that typically have access to a trust agreement are the grantor, who's the creator of the trust, the trustee, who's the fiduciary, whose job it is to administer the trust, and then the beneficiaries, so the folks that are named in the trust agreement to have the benefit of the trust assets. Outside of that, in general, there's no right for any other third parties to obtain a copy of the trust. So there's certainly an element of privacy with the trust agreement that you don't have with the will that is subject to probate. I mean, obviously, if you have beneficiary designations on real estate is a poor example there, because a deed is public record too. Anybody can go to the courthouse and look through the deed books. But aside from that, I mean, if your investment accounts, your bank accounts, things like that, if you have beneficiary designations on those such that they don't go through probate, that kind of takes the transfer of those assets out of the public purview as well.
But if someone were to try to find information and they're looking into it and they're like, oh, Bob Smith just died, they go to try to find Bob Smith's house, and Bob put his house in his trust, or had the trust own it, they can't find Bob Smith's house because Bob Smith doesn't own the house.
Yeah.
Is that right?
You may be, I mean, if you are doing a deed search, someone would be able to see that a property was conveyed to a trust, but they don't know who the beneficiaries of the trust are.
Gotcha.
Yeah. So it kind of provides privacy at that level.
It just says the Bob Smith Family Trust, or it's just, just family trust or something that is not, if it was TOD and you had both your kids, it could have both their names on it, but that's better than not having anything where it would be exposed to probate.
Yeah. And I mean, not to go down too much of a rabbit hole, but for clients that are very concerned with privacy, I've had clients that put their residence in an LLC. Because then if you look at the property records, all that you see are the LLC that owns the property, and you don't know who owns the LLC. That information is generally kept private as well. So whether it's a trust or an individual or 6 layers of entities, that's another option for kind of probate, or not probate, but kind of privacy and elements of privacy if that's a concern.
All right, so keep your LLC hat. That was
Okay.
some good stuff. Keep your LLC hat on. I got one for you. This is for all our business owners out there. So if you have an LLC with multiple members in the LLC, and one of the members dies, does the will or the LLC operating agreement take precedence?
So it would depend. I mean, you'd have to look at the terms of the operating agreement. I mean, typically, if there's a buy-sell arrangement or some type of like purchase option or redemption option that's part of the operating agreement, that in all likelihood is going to be binding upon the heirs of the estate, but it kind of depends on the terms of the document and how that's worded.
Gotcha. Okay, that's good. All right, going back to, we've got a couple of questions on DAFs. This is great. Just remember, keep them coming. So,
but if you do have to leave at 5:30, we understand.
Yes. So are DAF charities restricted as those of CRUTs, like 501c3 organizations?
Correct. Yeah, it has to be the recipient of a distribution from a DAF has to be a qualified charitable organization like a 501c3.
Yeah. And I'll state on that, there can even be more restrictions depending on the donor advised fund.
Correct.
That's correct?
Yeah, that's one of the great things about that is the whomever the decision makers are as far as how the distributions are going to be made from the donor advised fund. So if I'm setting up a donor advised fund, I can put whatever parameters on the potential beneficiaries that I want to. I can say that it only goes to organizations that support animal rights and animal welfare. And that's it, unless someone else comes along and changes that after I'm gone. But yeah, you can be as restrictive as the sponsor organization of the DAF would permit you to be.
Yeah,
I mean that's going to be
the sponsor organization. It's really up to them how they want to restrict those. Yeah. But overall, overarching in general, 501c3. You've got to have a 501c3 to make it happen. Any other restrictions besides that are going to be determined on the sponsor organization.
Yeah.
So that's
and whatever kind of governance documents you have for the management of that DAF with the organization.
Now, as far as DAFs, what kind of assets can you put into a DAF? The question specifically is, can you donate stock to the DAF? And what are the tax implications of that?
Yeah, again, that will depend upon the kind of the flexibility or the parameters that the sponsor organization has set up. But sure. Yes, you can donate stock in closely held business interests or stock in closely held businesses, LLC membership interests. Those could be donated to a donor advised fund. I mean, the tax implications of that can vary a little bit. Yeah. Depends on the circumstances, but typically you may not get the same. There's typically some limits as to what your donation deduction is with a closely held business. But if you are looking to potentially sell your business down the road, there's some significant income tax planning advantages to transferring some of the ownership in that prior to a sale versus proceeding with the sale and then donating some of the proceeds afterwards. Yeah. So something to discuss with your advisor.
Yeah. So let's simplify it a little bit. Let's just say publicly traded stock. So if I have like highly appreciated Coca-Cola stock, the benefits aren't just going to be whatever the market value of the stock is. There are a lot of, it's based on income levels and everything like that.
Yeah. And to that point, if you have highly appreciated publicly traded stock, you are going to get the benefit of the value of that when it's donated, but then that asset can be sold by the DAF or similarly with other types of kind of charitable trusts. And they're not going to pay the same. They're not going to have the same income tax burden that you would have as an individual if you sold that asset.
That's a win-win.
It is a win-win.
Yeah. All right. I know we're right around 6:30. We want to be cognizant of everyone's time. Thank you again for showing up. If you've got more questions, again, feel free to bring them on before we end, and we'll be sure to get them to Josh. One question, Josh, for you.
Yeah.
How often should people review their will, trust, or estate planning documents?
Yeah, I usually tell folks, I mean, it's a good idea every 4 or 5 years to kind of take a look at the documents that you have and make sure what you have still makes sense. Now, if there's some type of major life event that happens in the interim, if you either your family grows, like you have additional kids, or
Guardianship.
you lose a family member, your spouse passes away. If there's a significant financial windfall, your business has gone from a little business to now it's a big business. I mean, there's some triggers, just kind of intervening life events that would kind of warrant a review. I mean, if there's a major tax law change, that can sometimes be a good trigger to kind of look at what you have. But aside from those kind of things, I think 3, 4, 5 years, it's a good idea to kind of take a look at what you got and make sure it still fits.
And if it doesn't, is it better to amend the document, or should you just start from scratch?
I mean, I think that depends on the circumstances and kind of what changes you're looking to make. I think in some cases it's easier to just start fresh. In some cases, a quick modification is a better option.
Okay, great.
Customization.
That's right. That's right. And well, I'd say that's it. I know there are a couple questions that we'll be answering offline later on. So, Josh, Kelly, Hirschler, thank you so much for your time.
Yeah, you're welcome. My pleasure, guys. It was fun.
Yeah. And from all of us at the Legacy Advisor Group, if you guys have any additional questions, feel free to email us. And I think that's a wrap for tonight.
All right.
Take care, folks.